Welcome. I am Judge Halstead, and I'm the Chief Judge for the County of Kalamazoo Probate Court. I believe that persons may be appointed as guardian for minor children often have many questions with respect to what their duties are and what their responsibilities are. We have developed a video which may assist you in understanding what your responsibilities are to the minor children, as well as what duties you may have that are required by the court. In addition, it will give you also an idea of what rights the families have with respect to these minor children. We hope that by watching this tape, you will have a better understanding of your responsibilities. If you do have questions, I would suggest you consult with an attorney if those questions are not covered by the videotape. Also, if our court can be of any assistance, I would indicate to you, feel free to contact our court for any additional information. After viewing the video, if you do not feel you wish to be a guardian, please indicate the same. If you do feel that you can accept the role as a guardian for these minor children, then I applaud you for this valuable service that you will be providing to these children. Once again, I thank you for your participation.
A minor is sometimes in need of another person to provide for their care. The reasons can vary as to why a parent cannot care for their children. The court uses words such as power of attorney, limited guardianship, or full guardianship. It depends on what the parent's circumstances are as to which they need to make sure the minor is provided proper care. What is a power of attorney? What can or can't it do to meet a family's needs? The power of attorney is executed by a parent, giving the parents power regarding the care, custody, and property of a minor to another responsible adult. This allows the responsible adult to provide care for the minor, take custody of the minor and his or her personal property. The Supreme Court has ruled that a power of attorney may be used to establish school residence when the child resides with a relative. The power of attorney allows a responsible adult to make decisions regarding the child, especially those decisions centered around consent to medical care. In case of emergency, the responsible adult will be able to make a decision. For example, to have a minor child's arm placed in a cast if it were broken. A power of attorney gives a parent or parents the best or ideal way to take a trip or leave town for a short period of time without the necessity of having a court hearing. In fact, when a parent or parents leave town, even for a short period of time, someone should have the authority to make decisions regarding those children, especially those decisions regarding medical care. One advantage of power of attorney over guardianship is that it does not act to limit the power of the parent if the parent chooses to act. The power of attorney does not give another responsible adult the power to consent to an adoption or marriage, nor does it have a renewal clause. A power of attorney needs to be redone every 6 months. Sometimes it is necessary to have a court hearing to appoint a responsible adult as a limited or full guardian. For example, grandparents, aunts, uncles, cousins, or concerned friends may be appointed by the court to be responsible for the care and custody of a minor child. An appointment can be made with the intake specialist at the probate court. When you meet the intake specialist, you should bring the minor's birth certificate and Social Security number, along with the parent's current address and telephone number. If the parents are deceased, you should bring current addresses of adult siblings and grandparents. If it applies, you may also need to bring an affidavit of parentage or order of filiation, a judgment of divorce or the last custody order, a parent's death certificate, Child Protective Service worker's name and telephone number. The intake specialist will assist you in the filling process. However, you must be aware that the intake specialist cannot give legal advice. Another option being used by parents is to appoint a guardian for a minor by will or other writings signed by the parent and attested to by at least 2 witnesses. What is limited guardianship? A limited guardianship gives a parent the means to voluntarily petition the court to allow someone else to assume their parental duties. A limited guardianship placement plan is also filed with the petition. The advantage of a limited guardianship is to allow the parent or parents the opportunity to rectify their circumstances which resulted in the need for a limited guardianship. This could be establishing proper housing, financial security, or completing educational goals. The petition is filed by a parent or parents along with a limited guardianship placement plan. The limited guardianship placement plan is filed along with the petition and must be signed by the parent or parents and the proposed guardian. The plan must include the reason why the parent or parents are requesting the guardianship, the parenting time and contact with the minor by his or her parent or parents, the length of the guardianship, the financial support for the minor, other provisions the parties agree to. The parents must be aware that they are agreeing to this plan, and if they fail to comply with the placement plan without good cause, they could lose their parental rights. The difference between a limited guardianship and a full guardianship is that a limited guardianship does not allow the guardian to adopt or sign for the minor to get married. The limited guardianship continues until the parent with legal custody files a petition to terminate the guardianship, or unless a date certain is agreed to on the limited guardianship placement plan, or the minor turns 18 years of age. What is a full guardianship? What can or can't it do for a family? The court can appoint a full guardianship for the following reasons. The parental rights of both parents or the surviving parent have been terminated or suspended by prior court order, judgment of divorce or separate maintenance, death, judicial determination of mental incompetence, disappearance, or confinement in a place of detention. The court must determine a basis for both parents to establish a guardianship for a minor. One parent might fit under one basis, for example, death, and the other parent might fit under another basis, for example, disappearance. If the minor child is born out of wedlock and the father's paternity has not been determined in a manner provided by law, the basis for establishing a guardianship will depend solely upon the situation of the mother. The court may also appoint a full guardian when the parent or parents permit the minor to reside with another person and do not provide that other person with the legal authority for the care and maintenance of the minor, and the minor is not residing with his or her parents when the petition is filed. There are many situations when parents have disappeared or have been incarcerated, and the minor children are left in the care of grandparents, cousins, relatives, friends, and the like. A full guardianship would give these individuals legal authority to make decisions regarding the minor children. The court may also appoint a full guardian if all of the following circumstances exist. The biological parents have never been married to one another. The parent who has custody of the minor dies or is missing. The other parent has not been granted custody under court order. The person who the petition asks to appoint as guardian is related to the minor within the 5th degree by marriage, blood, or adoption. After a petition has been filed for either a limited or full guardianship, the court will enter an order directing a court-employed social worker or Family Independence Agency social worker to investigate the proposed guardian, parents, and the minor children's present home situation prior to the formal court hearing. This investigation will include a visit to the home of the proposed guardian. The investigation will consider the reason for the guardianship, the determination of legal custody, any special needs of the child, any medical problems of the child, the educational status of the proposed guardian, and any counseling or psychological evaluations completed on any of the interested parties. In addition, the investigation will include the financial status of the proposed guardian, the criminal record, if any, and whether there is adequate space in the home for the minor. The social worker will also consider the reason for the guardianship before submitting a written analysis or report of the family's past and present environment. The social worker will make a recommendation to the probate judge as to whether the guardianship should be granted based upon the best interest of the child. The social worker will provide a resource list to the proposed guardian. This list offers the proposed guardian an understanding of where to obtain help once the guardianship is granted.